The Supreme Court in its recent verdict has given a big boost to the fight against corruption. It ruled that its 2014 verdict, which had struck down a provision of the Delhi Special Police Establishment Act, which provided immunity from arrest for officers, will have retrospective operation. What is this case? What was this 2014 verdict? Let's understand. So, Delhi Special Police Establishment Act was passed in 1946. CBI was a special police establishment established in 1941. Later, the Santhanam Committee on Prevention of Corruption recommended the establishment of the CBI. CBI is the main investigation agency of the Government of India and it derives its powers from various acts, specifically from this Delhi Special Police Establishment Act. In this act, Section 6A was inserted in 2003. It provided that police establishment need to get prior approval to initiate an investigation against officers who are joint secretary level or above, or the officers who are appointed by central government or under any central act in central government corporations, etc. So, it made a distinction between officers and prior approval was required for initiating investigation against certain categories of officers. This Section 6A was challenged in the Supreme Court, and then Supreme Court in 2014 gave its verdict and quashed this Section 6A of DSPE Act. Before going in the detail of this, let's go back to 1969 before the insertion of Section 6 in the DSPE Act. In 1969, the Centre issued the Single Directive. This Single Directive was a consolidated set of instructions issued to CBI by various ministries and departments regarding modalities of initiating an inquiry or registering a case against certain categories of civil servants. So, before the Section 6A, the requirement to obtain prior approval of the government was contained in this directive known as Single Directive. So, it provided for a prior sanction of the designated authority to initiate investigation against officers of the government and public sector undertakings and nationalized banks above a certain level. According to the government, the said directive was necessary to protect senior officers from any malicious inquiry or investigation and to ensure that they were not victimized for taking honest decision. It was said that absence of such protection could adversely affect the efficiency and efficacy of the government institution because of the tendency of such officers to avoid taking any decision which could later lead to their harassment by way of frivolous charges or investigation. In response to this, Vineet Narayan, a journalist and a social activist, approached the court and filed a complaint against CBI in 1993 that it did not take actions when the matters were related to high-ranking officers, and therefore it raised question of constitutional validity of this single directive. This case came to be known as Vineet Narayan and others versus Union of India. The Supreme Court then delivered its justice and quashed this single directive. The bench ruled that every person accused of committing the same offence is to be dealt within the same manner in accordance with the law. The court also held that single directive is invalid on the ground of legislative competence because it interfered with the powers of CBI conferred under DSPE Act by way of an administrative instruction issued by the government. So, in response to this judgment, Centre brought back a similar provision in place with an ordinance in the CVC Act on August 1998. However, when this ordinance lapsed and it was introduced as a bill, it could not pass because Lok Sabha dissolved in 1999. Later on, it was reintroduced in 2003 and it received the assent of the President. Now coming back to Section 6A. It remained on the statute book for a period of more than 10 years till the Supreme Court quashed it in the case of Subramaniam Swamy versus Union of India. And that is what 2014 verdict is. In 2014 verdict, the Constitutional Bench held that this provision was unconstitutional, violative of Article 14. According to the court, status or position cannot shield an officer of the level of Joint Secretary and above from unconstrained probe by CBI in cases of corruption. So the court ruled in 2014 that CBI does not need to seek approval for the investigation. It termed Section 6A a discriminatory provision which impedes tracking down the corrupt senior bureaucrat and said that the protection in Section 6A has propensity of shielding the corrupt. However, in the judgment, it did not specifically mention whether the protection of prior sanction would be removed from the date of the judgment in May 2014 or had effect from when Section 6A was inserted in 2003. So, it did not make it clear whether those who are booked between 2003 September and May 2014, they can be prosecuted without government approval or not. In the current judgment, the Supreme Court declared that the provision under Section 6A of Delhi Special Police Establishment Act is void from its inception. CBI no longer needs to seek prior permission from the government to investigate or prosecute cases filed before 2014, the date when the provision was declared unconstitutional by the Supreme Court. So that is what retrospective means. A similar section of Prevention of Corruption Act is also under scrutiny. This Section 17 of the Prevention of Corruption Act was inserted in July 2018. It revived protection for government servants by bringing an amendment to Prevention of Corruption Act. The Section 17 added to the Prevention of Corruption Act extended the immunity from prosecution without prior sanction to not only serving government officers but also to the retired ones. It provided that all government servants, irrespective of category, class or level, are protected from prosecution without prior sanction when the act is related to their official discharge of duty. However, if a person is caught taking bribe, then they can be arrested on the spot. There is no protection for that in this section. This act is also challenged in the Supreme Court. A PIL was filed by a civil society organization, Center for Public Interest Litigation. This verdict is likely to have a significant impact on corruption and other criminal cases initiated against government servants between 2003 and 18. What are your views? Let me know in the comment section. If you like this video, give a thumbs up. And for more such videos, subscribe to the channel. Thanks for watching.